So I'm going to talk today about planning for life, powers of attorney and representation agreements. I'm an estate planning lawyer, and so I deal with clients on helping them achieve their estate objectives. And you know, there are really two parts to it. A lot of people think estate planning, they think preparing a will. And a will is important, of course, for you to decide what happens to your estate, the things that you own, on your death. But there's another part to estate planning, and that's planning for what happens during your lifetime when you become incapacitated. And there's two aspects to that, of course. The first is who is going to deal with my financial affairs when I'm no longer able to do that myself. And that's what I'm going to talk about today under the heading of powers of attorney, and specifically enduring powers of attorney. The other side of the equation is who is going to help me to make personal care, medical, healthcare decisions when I'm no longer able to either make those decisions myself or communicate my wishes myself. And we have a tool called a representation agreement that I'm going to talk about that can help with that type of planning. So first I want to talk about what happens if you don't engage in incapacity planning. And you may have heard in the last week that the artist Prince died. And I read later in the week that Prince, apparently he had a $300 million estate, and his sister says that he died without a will, which is shocking. But it just goes to show you, people put off estate planning. People always think that they'll have time to deal with it later. So what happens if you don't deal with your incapacity planning? Well, I was chatting with somebody in line for lunch who was saying that they, with a relative of theirs, they missed the boat in that their relative, by the time they got around to the trying to do a power of attorney, their relative was no longer had the capacity. And in that case, they were able to wing it. It was the way that it was put to me. I see a lot of clients who do this as well. So if you don't have a power of attorney in place, in some cases the family can wing it. And that just means that you may have pre-authorized payments coming out of your bank account. You may have things all nicely set up. Maybe you even have a joint name of one of the children on one of the bank accounts, so they can continue acting for you in an informal capacity. But there are limits to what you can do under an informal arrangement. So, for example, if the adult now needs to move from their house and move into an extended care facility, and maybe they need to sell the house in order to provide the money that they need for the care. Well, you can't sell a house if your name is on the title to the house. The house can't be sold unless you have the legal capacity to sign the paperwork, or you have a power of attorney in place, or somebody legally authorized to sign that contract for you. So if you don't have that in place and your family needs to take steps like that, then the only option for your family is to go into court and get an order for guardianship. And in BC that's called comiteeship. And so the court in that case appoints a committee for you, somebody who has the authority to act on behalf of you for financial affairs, and also in some cases make personal care decisions for you. The committee appointment process in BC is long, it can be complicated, it's expensive, and it can be quite arduous. It involves, among other things, you have to get 2 opinions from physicians to state that you're giving their opinion that you're incapacitated. If John was applying for comiteeship for me, he would have to inform me that he was making that application, and depending on my state of mind, I might not be very happy with that. So you can end up in quite a tense situation between often the child and the parent. Furthermore, in a family, I'm one of 6 kids in my family. In larger families, you may get 2 different siblings, or 3 or 4, who all think that they're the right person to apply for comiteeship. And maybe if I apply, then one of my sisters would say, well, you're not the right person. You can't even manage your own affairs, let alone our parents' affairs. And so you can end up with a contested comiteeship where everybody's getting lawyers and they're all fighting over who's going to be appointed as the comiteeship. Generally speaking, that's probably not the process you want for yourself and your family. So the way that you can avoid this is to make an enduring power of attorney. A power of attorney is simply naming somebody, giving somebody the authority to manage your legal affairs, And an enduring power of attorney means that it endures, it continues on in effect, even after you become incapacitated. Any adult person who has legal capacity can make a power of attorney. And so, generally speaking, legal capacity in this context means you have to understand what your property is. You have to generally understand who your family members are, and particularly your dependents. And you need to understand the nature of the document. So you need to understand that when you give a power of attorney, you're giving a lot of authority to somebody to manage your financial affairs for you. You have to understand that they could misuse that authority, and you have to understand that if they don't invest your assets well, it could cause loss to your estate. And so if I'm interviewing a client, I make sure that they understand those things before they put a power of attorney in place. How do you make one? Most people would go to a lawyer, like myself, to make a power of attorney. There are sites online where you can find forms that you can fill in as well. And when you sign it, the important part of a power of attorney, it has to be signed in front of two people, unless you sign it in front of a lawyer, and then you only need one person. Apparently one lawyer is worth two other people. I don't know who made that one. Probably a lawyer made that rule. And lastly, actually, for the English majors in the room, the line should read, whom should you name as your power of attorney? Well, obviously you're placing a lot of trust in somebody. Often it's a family member who you believe would be capable of managing your financial affairs for you. In some cases, if there's no appropriate family member, you might be turning to a trusted advisor or perhaps a trust company. So, 10 years ago when we were preparing powers of attorney, they tended to be all in the same form. They were one page and they didn't have very much in them. They just said, I'm naming this person to be my attorney, and I give them all of the authority to manage my affairs, and that was it. Powers of attorney have become more nuanced over the years, and there's some other things that you should think about including in a power of attorney. So for example, if you're naming your spouse as your attorney, normally a person acting under a power of attorney is not allowed to use the power of attorney to transfer property to themselves. It's a rule against self-dealing. But if you're naming your spouse as under your power of attorney, you actually might want them to have the power to transfer assets to themselves, to take care of themselves, or perhaps to do some estate planning and maybe avoid some probate fees or otherwise minimize taxes. You might also, for somebody who is in a regular habit of providing financial assistance to family members, kids in university, for example, or sometimes beyond, you may want to include a power in the power of attorney that specifically states, my attorney may use this power of attorney to benefit either my family members generally or these specific people. Sometimes I meet with clients who are in the habit of, they regularly make charitable gifts. It might be their church, it might be one of their favorite health-related charities, and they want that to continue. So a person acting under a power of attorney is only allowed to use the assets for the benefit of the adult patient, unless the power of attorney says that they can continue making gifts. And it may be advisable to put limits around to whom gifts can be made and the amounts. You might want to include a power to reorganize affairs, conduct estate planning, and again, tax minimization. Some other clauses that we sometimes put in there. An attorney, if the power of attorney is silent, then the attorney is not allowed to claim any compensation or payment for acting as attorney. And so you might want to put, particularly if it's not a close family member, maybe it's an accountant or a financial advisor who's acting. In that case, you definitely want to include a clause to say how much is this person going to get paid to carry out the duties under the power of attorney, which sometimes can take quite a bit of time. And also you may want to, in a more advanced power of attorney, you might want to split roles between different people and say, I name this person to take care of my business, but my personal affairs I want my other child to take care of. Sometimes when we're planning with clients, we also, we can use trusts as alternatives for capacity planning tools. This is a little bit more advanced, but the general idea here is that I can take the property that I own, I can take my house and some of my investments, transfer them into a trust, so transfer them to a trustee who holds for the benefit of me during my lifetime, and then the trust specifies to whom the property will go on my death. The way that this can be used for incapacity planning is when I set up the trust, I could be the first trustee, or if I'm starting to have trouble managing my affairs but I still want to stay involved, I could name John as my co-trustee, and we could manage the trust together. Can I trust you, John?
Sure.
And then when my health declines to a stage where I no longer want to be focused on managing my financial affairs because I just want to be focused on relationships and health, then I can resign as trustee and the management smoothly passes to my co-trustee. Okay, next I just briefly want to talk about the other side of the equation, how to plan for healthcare. I'll take questions at the end, but so just in a few minutes. So how do you plan for healthcare and personal care? With a lot of our clients, we're making representation agreements. A representation agreement is like a power of attorney, but you're naming a person, giving them the authority to make healthcare and personal care decisions on your behalf. Do you need a representation agreement? Well, there is a statutory default in place under the Healthcare Consent and Care Facility Admission Act of BC that says that if you don't have a representation agreement, a physician is entitled to turn to the next person who's listed on a list of default substitute decision makers in that act. And so it goes to your spouse first, and then to a child, and then to parents, and out to brothers and sisters. So it follows a statutory scheme. So if you don't have a representation agreement, it's possible for a physician to turn to somebody in your family as a substitute decision maker. However, if you want certainty as to who's going to be making healthcare decisions for you, or maybe you want to you're not happy with the person who would have the authority under the statutory scheme because maybe your child is not the person that you'd want making those decisions on your behalf, then you should make a representation agreement. Who can make a representation agreement? Well, there's two different kinds. There's one type of representation agreement that gives a broader scope of powers, and in order to make that type of representation agreement, we call that a Section 9 agreement, you need to have full capacity like you do for a power of attorney, and so you need to understand fully the nature of the document that you're signing. There's another type of representation agreement called a Section 7 agreement. It gives a more limited scope of powers, so some of the more important healthcare decisions, for example, around end of life, can't be made under a Section 7 agreement. But a Section 7 agreement can be made by somebody who has more limited capacity. And they basically just need to, I won't go into all the tests, but they basically need to generally understand who the person is that they're dealing with, and they should demonstrate a relationship of trust with that person. What's the difference between a representation agreement and sometimes you'll hear about a living will or a memorandum of wishes regarding healthcare. Well, if I name one of my family members under a representation agreement, I name let's say one of my sons, although they're a little young for it, but if I name one of my sons as my representative, they are required by law to follow, in exercising the power under that representation agreement and making healthcare decisions, they're required to follow any wishes that I've set out during my lifetime. And so a living will or a memorandum of wishes is a non-binding statement that I make regarding the type of care that I would want in certain circumstances, and I'm asking them to follow those wishes. Often living wills or memoranda of wishes will cover off especially the type of care that I want around the end of my life, and particularly a lot of people feel strongly that if there's no reasonable prospect of recovery, that they don't want medical care to artificially extend their life. That's a common thing that my clients ask for in those documents. The other document you might hear about if you're dealing with the healthcare system is called an advance directive. An advance directive is different from a representation agreement, whereas in a representation agreement you're naming a person and giving them the authority to make decisions on your behalf when you're no longer able to do so. An advance directive is basically it's a statement, it's a binding statement of wishes made directly between you and your physician. An advance directive is specific with respect to care, and so it only applies to the types of care that are described in the advance directive, and an advance directive will trump a representation agreement. So if you have a representation agreement in place, and then you're going into a hospital or medical facility, and you're being asked if you want to sign an advance directive, you have to realize that whatever you put in there, anything that you specify in your advance directive, you will now be taking that authority away from your representative because you're giving your wishes directly to your physician under the advance directive. And sometimes that can cause a bit of conflict. It's something that should be carefully discussed and thought out at the time. So I'll turn to questions now, but just in closing, planning for incapacity, I find when my clients engage in this process, sometimes it's a little bit difficult to think about these things and to think ahead about what will happen when you're incapacitated. But I find that going through the process, at the end of it, my clients have the peace of mind that comes with knowing that the plans are in place. And so, I would encourage you, if this is something that you haven't yet done for yourself or for a loved one, that you think carefully about it. And with that, I'll open it up to questions. I know we had one back here.